Good morning to you all. Advocate Minya.
Chair, good morning, and to the commissioners. We have Lieutenant General Mutiba to testify this morning.
Virtually.
Yes, by my colleague.
Yes. Ms. Ranto, are you going to lead your witness?
That is so, Chairperson.
Thank you. Lieutenant General Mutiba, can you hear us?
They're muted.
Lieutenant General, can you hear us? Can you hear us, General?
Commissioner.
Yes, you are now audible. Are you going to take an oath or affirmation?
An oath, Commissioner.
Yes. Do you swear that the evidence you will give will be the truth, the whole truth, nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you, Lieutenant General. Ms. Ranto, your witness.
Thank you, Chairperson. Good morning, General Mutiba.
Good morning, Advocate.
There is an affidavit in front of you that is dated 1st July 2026. Can you confirm if you have it in your possession?
I confirm, Commissioner.
Do you also confirm that you are the one that deposed that affidavit?
I confirm, Commissioner.
Can you also confirm that you have knowledge of the contents of the said affidavit?
Yes.
Okay. In paragraph 1 of your affidavit, you inform the commission that you are a retired member of the South African Police Service, correct?
That's correct.
Can you just tell the commission as to when did you retire?
I retired in 2019.
What was the reason for your retirement?
I retired, I went on pension. I left the police when I went on pension at the age of, at the pensionable age.
Thank you. In paragraph 3, you inform the commission that this affidavit was prepared in response to the commission's letter dated 24 June 2026. Is that so?
That's correct.
And then perhaps if I may also get your confirmation, you annexed to your affidavit a letter marked LJM1 to your affidavit.
That's correct, Commissioner.
Can I confirm that is the letter that you are talking to in your affidavit?
That is correct.
Okay. Before dealing with the letter from the commission, I would like to request you just to briefly inform the commission or give some background of who you are, maybe starting with your qualification and then tell us a little bit of your career progression whilst you were in the SAPS.
Commissioner, after matriculating, I joined the South African Police Service. In 1989, I obtained my diploma in policing from Technikon South Africa. That time, it was incorporated into UNISA later. In 1994, I obtained my degree in police science. In 1997, the honors. And then in 2019, I completed my master's degree. In 1982, I joined the South African Police Service, and I've been in the South African Police Service since then. I've worked, I went through the ranks In 1985, I was promoted to the rank of sergeant. As a constable, I was doing general charge office duties, guard duties, and uniform investigation. I was later promoted to a warrant officer. And then in 1989, I was appointed as a lieutenant and as commander of foot rail section at SAP Hammarskraal College. And now I remained at the college, becoming a captain, a major, lieutenant colonel, until 1996. 1996, I was appointed a colonel at Alexandra Police Station. And it was when I was at Alexandra that the commission came to, the Truth Commission came to Alexandra on about 3 occasions. And I was assisting the security personnel of the commission that were doing security of the commission. My members and myself were also assisting there. And then in 1997, I became the station commander at Alexandra. In 2004, I came to head office as the component head in the training division. In 2010, I became the divisional commissioner for visible policing, responsible for all uniform members in the South African Police Service. In 2013, I was appointed provincial commissioner in Gauteng. In 2016, I came back to head office as the regional commissioner, Region C, responsible for oversight and audits in the Eastern Cape, Northern Cape, and Western Cape. In 2017, I was appointed the acting national commissioner for a period of about 5 months. And then after the appointment of the national commissioner, I went back to my role as the regional commissioner for Region C until my retirement.
Thank you, General. In paragraph 8.4, as you just informed the Commission, you stated that you acted as a national commissioner. And in your statement, you say it was from 1st June 2017 to 22 November 2017. Is that correct?
That's correct, Commissioner.
Okay, so that would have been approximately 5 months.
Yes.
Can you explain to the Commission as to what your roles and responsibilities were during your tenure as as the acting national commissioner?
My role was that I was the accounting officer of the organization, and I was responsible for crime prevention, crime combating, crime investigation, resource management and resource allocation, management of public order policing. So in a nutshell, the PAX was stopping with me when I was acting national commissioner.
Insofar as operational support was concerned, which divisions or units resorted under your command as a national commissioner?
It was the detective service, the visible policing, the forensic, the support, all of them, with the exception of the DPCI, the Directorate for Crime Investigation. It wasn't falling under me. So anything policing was falling under me.
Thank you. Perhaps if we'll go back to what you just informed the Commission, that the DPCI did not fall under your command. Perhaps if we can just go to the notice LJM1, if I can just refer you to LJM1, General. And then paragraph 3 specifically. If you can read out paragraph 3 up to 3.1, please.
You are requested to assist the Commission and furnish us with an affidavit addressing your knowledge of relevant events and matters In particular, your affidavit should set out your role, responsibilities, and authority as National Commissioner of the South African Police Service during your tenure in as far as they relate to the investigation of TRC cases.
Thank you. And then in your affidavit, specifically paragraph 9 of your affidavit, you make statements there, and specifically 9.1, well, if I may start from paragraph 9, you stated that during my tenure as the acting National Commissioner of the SAPS, I have never directly or knowingly exercised oversight, gave direction, supervised, coordinated, or supported investigation in relation to the TRC cases. Is that correct?
That is correct, Commissioners.
And then if perhaps you may inform the Commission as to why you would not have exercised that oversight as indicated in 9.1. What would be the reason for you not to have had performed such a function?
The reason is that the TRC cases are classified as priority cases. And the priority cases are allocated or were allocated to the DPCI. And the National Commissioner of the South African Police Service is having no command and control over the DPCI. So the DPCI is totally independent from the South African Police Service, except, of course, in as far as matters of budget are concerned. But overall, I was not having any command and control over the DPCI.
Okay, when you said independently, where do they report from your knowledge? Where is the reporting line when you talk of the DPCI?
The DPCI is reporting to the Minister of Police, who is also responsible for appointing the head of the DPCI and to Parliament.
And then in 9.2, you also indicate that you never received any report or briefing, and you were never involved in decision-making or resource allocation process that had to do with the investigations to the TRC cases. Is that not so in your statement?
That is correct.
Now, you indicated earlier that you were the accounting officer for the South African Police Service. And now I would like you to explain as to why you would not be, or you stated in terms of what is contained in 9.2 about not being responsible for resource allocation, even though you were the accounting officer.
The budget of the DPCI is appear on the budget, the overall budget of the South African Police Service, but it is ring-fenced to say this is the budget of the DPCI, and the National Commissioner cannot even touch a cent of that budget. So the DPCI is only coming to the South African Police Service to get their budget, which has been voted at Parliament. So the National Commissioner cannot touch that budget. But the DPCI, of course, would, through the channels, ask for additional budget, which budget would go to them. The police, the National Commissioner will not interfere in that budget.
Thank you, General. And 9.3, you also state or inform the Commission that you never issued any instruction or made any requests for interventions relating to the TRC cases. Is that correct?
That is correct.
You also state in paragraph 9.4 that you were never involved in any efforts which sought to influence, delay, limit, discourage, or stop the investigation of such matters. Is that correct?
That is correct. Otherwise, I would have been charged for interference in the work of the DPCI, of which it is a criminal offense for the National Commissioner to encroach into the role of the DPCI. which is totally independent from the South African Police Service.
And then 9.5, you informed the commission that you never issued an instruction that sought to undermine the investigation of any TRC cases or any other matter to any official member of the SAPS. Is that correct?
That is correct, Commissioners.
And then you proceed in paragraph 10 to say that you were not privy to any communication and or interactions between the SAPS, the National Prosecuting Authority, the Department of Justice and Constitutional Development, members of the executive, or any other persons or institutions concerning the investigation or prosecution of TRC cases. Is that correct?
That is correct, Commissioners.
And furthermore, you indicated that there is no information in your possession that relates or related to the TRC cases. Is that not so?
That is correct, Commissioners.
And in paragraph 11, perhaps if you can read it out to the commission on record, paragraph 11 of your affidavit, just under conclusion.
During my entire career in the SAPS, I always strive to adhere to my legal obligations as outlined in Section 205 of the Constitution and never engaged in any act of political interference aimed at stopping the investigations and or prosecutions of the TRC cases.
Thank you, General. Commissioners, that will be all from the witness statement.
Thank you, Ms. Ranto. Ms. Moroka,
No clarification questions for this witness, Chair.
thank you. Mr. Kwala,
Thank you, Commissioners. We do not have any questions for this witness.
thank you. Mr. Masuku,
Chairperson, we have no questions for this witness.
thank you. Mr. Vani. Thank you. Mr. Siminya or Ms. Ntambeleni,
Thank you, Commissioners. No questions for this witness.
thank you.
Chairperson, is it all right if I ask the questions on behalf of the evidence lead?
Yes, you may, Mr. Soni.
Thank you, Chairperson. Commissioner Matiba, can I ask you, what position were you holding at the time you were appointed acting commissioner?
Commissioner was holding the position of Lieutenant General.
And you took over as acting commissioner on the 1st of June, 2007.
Speak into the microphone.
2017.
Mr. Soni, speak into the microphone.
Oh, sorry. I'm trying to see the witness, but I understand. You took over as acting commissioner on the 1st of June 2017, Commissioner.
That is correct, Commissioners.
When was Commissioner Pashlane suspended?
Commissioner Patlane was suspended at the end of June. I think it was the 30th of June, 2017.
And you took over the very next day?
That is correct, Commissioners.
So I take it, given that Commissioner Pashlane was suspended the day before you took over, there was no handover from him to you?
That is correct, Commissioners.
Now, you were acting commissioner for a period of just more than 5 months, is that correct?
That is correct, Commissioners.
You're aware that in terms of the Police Act, the commissioner is required to prepare reports to the minister and to Parliament.
That is correct, Commissioner.
During the period you were acting National Commissioner, did you prepare any reports dealing with police service?
Yes, a number of reports.
And what were those reports?
They were on operational matters. We appeared in Parliament, I'm not sure how many times. We reported to Parliament on on our progress on our plans. We reported to Parliament on the crime statistics and so forth.
Now, can I ask you, were you aware at the time you were National Commissioner that TRC matters were priority crimes?
Yes, I knew, Commissioner.
But were you aware of that?
I was aware of that, but I knew also, as I do now, that they were not the responsibility of the South African Police Service. They were the responsibility of the DPCI.
And who was the head of the DPCI at that time?
I don't want to talk under correction. I can't remember who was the head that time, because General Via was not in the police that time. He has left the police. So I can't remember who was the head of the DPCI that time.
Oh, but would you have communicated with him during the period you were National Commissioner?
Yes, on numerous occasions.
Okay. Now, one of the things that the Police Act requires is that in terms of Section 17K1, the National Commissioner must include in his national report or his annual report to Parliament on the performance of the DPCI. When you went to the Parliament, did you make a report to Parliament on the workings of the DPCI during the period you were there?
When Parliament was calling the police, we would go together with the DPCI. The DPCI will present on their mandate. The South African Police Service would present on their mandate as well.
Yes. So your report would have included the report. So the police report to Parliament would have included your report on the overall SAPS position, and the DPCI head would report on the priority crimes which he oversaw.
I'm not sure whether I understood the question, but the most important thing is that I never reported on DPCI matters.
No,
yes, it was one report, but the DPCI were responsible for their portion. At no stage would I have reported on the DPCI matters, but of course I would be privy to their report.
When you reported to Parliament, was the DPCI report contained in your presentation to Parliament, although drawn up by the head of the DPCI?
There's one report that I can safely say that it was there. And that was the annual report of the South African Police Service for 2016-2017. That is where the DPCI would feature, of which that document is available. But in terms of the other reports going to Parliament, the DPCI would have their own reports, and then myself and the police would have our own reports.
I'm just trying to find out how we would be able to lay our hands on the reports that the DPCI sent to Parliament.
The commissioners will pardon me because I'm no longer in the South African Police Service. Otherwise, I would have said that you will get it by this afternoon or tomorrow. But that report is there. It is the annual report of the South African Police Service for 2016-2017, of which that report is also available on the SAPS website.
And that is the DPCI report.
The DPCI report is contained in the SAPS annual report for 2016-2017. Even for every year, for every financial year, when the SAPS annual report is made available, it is having a portion that speaks to the DPCI.
And that report would be drawn up by the head of the DPCI.
That is correct, commissioners.
And if we found the total SAPS report for 2016-2017, we would also find the DPCI's report for that period.
That is correct, commissioners.
Now, I just want to, and I say this, Chairperson, to understand how the need for a separate report from the DPCI came about is, if one looks at the Glenister 2 case, Parliament in the Constitutional Court insisted that the DPCI remain independent from the Commissioner of Police, because that was the challenge to the provisions of the Police Act when it was amended in 2008. And this amendment that the Commissioner is talking about resulted in separate reports being prepared. And that is why, although it is one SAPS report, we are asking the Commissioner for the report of the DPCI.
Yes.
Commissioner, as I understood your evidence, you say that all these reports would be available at the SAPS head office.
That is correct, Commissioner.
In the circumstances, Chairperson, may I request that a directive be given to the representative of the SAPS to submit all reports of the DPCI starting from 2012, when they started presenting separate reports to Parliament.
Starting from?
2012, Chairperson.
Yes.
Those are our questions,
Yes.
Chairperson.
Ms. Ranto?
Sorry, thank you, commissioners. There will be no re-examination of the
Yes.
witness.
Did you hear the request for
I
the
did,
directive?
indeed, Chairperson.
And you will
Noted.
attend to it accordingly.
We will attend to it,
Thank you.
certainly, Chairperson.
Lieutenant General Mutiba, we thank you for having presented yourself before the Commission for your evidence. You are excused as a witness.
Thank you, Chairperson. I appreciate.
Yes, we'll take a short adjournment until 11:15. Senior.
Chair and Commissioners, at the request of the Kalata Group, we have recalled Mr. Jafta for further cross-examination.
Yes. Mr. Jafta, you are reminded that you are still under your former oath.
Yes, good morning, Commissioners.
Thank you.
Yes, thank you.
Mr. Vani.
As the chairperson pleases. Mr. Jafta, firstly, thank you for agreeing to come back to the Commission to answer questions from the families, otherwise known as the Kalata Group. These questions deal largely with your evidence in chief, which I found very useful. I enjoyed the deeper dive in which you took the Commission and the insights that you provided. And today I'd like to elaborate a little further on some of those questions. We have provided you with most of our questions already, so you've got a good sense of where we're going. And perhaps we can start with the question that we pose. And if you do have a copy of our application, it starts at paragraph 6.1. You've mentioned that you were previously an intelligence officer. Can you indicate what that role entailed, without giving away any state secrets? You don't have to indicate the kinds of intelligence you were uncovering, but the role of an intelligence officer, what was your day-to-day work about?
Commissioners, once more, good morning and to everybody. It is very, very difficult to imagine how one can answer to that question without pointing an educated eye into what I did, which is not desirable in terms of the legislation that governs intelligence. The broad functions of the civilian intelligence structures of the Republic are outlined in the relevant legislation. And I would suppose that for the purpose of the Commission, that should suffice. If I was to go beyond that, I would be at risk of violating other provisions that govern.
Mr. Jafta, you may wish to face the chair and not Mr. Van.
Oh, pardon me for that.
Speak,
yes, yes. So I was just saying it would be impossible to give an answer without divulging what I shouldn't divulge in law.
But would I be correct in saying that it was essentially an analytical role where you would have to look at information and data, analyze it, and provide reports and recommendations? You would have to cultivate leads and sources and the like.
Can I pray that I don't answer questions about my responsibilities in intelligence? And I'm going to repeat myself. Any answer to that question immediately points at what I was doing, and that I don't have the liberty to disclose that.
And can you set out your main responsibilities while you were employed at the presidency?
In the presidency, there was an entity called the Policy Coordination and Advisory Services Unit, commonly referred to as the PCAS. It was formed in order to ensure and to facilitate an integrated approach to the development of policy, the program of action of the government, the sequencing of the elements of that program of action, monitoring and evaluation, and providing advice to the political principals in the presidency and obviously including the cabinet committees responsible for the various clusters of government. So in a nutshell, one was responsible in that policy unit for the cluster responsible for the administration of justice, law enforcement, and national security. And that cluster is commonly referred to as the Justice, Crime Prevention, and Security Cluster, the JCPS.
Thank you. If we can now turn to the TRC cases, which is the subject matter of this commission. At any point, did you become aware of meetings that had been held between the former generals of the apartheid-era security forces and senior members of the ANC, which took place in the 1990s and carried on through to the early 2000s? And the apparent aim of these meetings was to look at alternatives to prosecutions.
Commissioners, I'm going to answer this question in this fashion. I want to be careful between stating a fact that I can be held accountable for and expressing a view, an opinion, based on any number of variables. In this instance, I have no factual knowledge of meetings that took place between generals either of the police, South African police as it was then known, or the South African Defence Force as it was then known, and anybody who was in the leadership positions of the African National Congress. Factually, I have no such information. So I cannot express a view about what happened there. Generally, it wouldn't surprise me, considering the transition that happened in our country, starting with the unbanning of the political organizations and the processes that happened before then. It wouldn't surprise me if such a meeting or such meetings occurred, but factually, I have no knowledge of those.
Why do you say that you wouldn't be surprised if such meetings were taking place?
Because even when the political prisoners were still incarcerated, there were engagements between functionaries of the apartheid regime with some of those political prisoners, and later there were engagements with various categories of functionaries of the apartheid regime, with various categories of officials of the liberation movements, and it is in that context that I wouldn't be surprised if such happened.
And if we can turn to paragraph 8 of your statement, it's under the heading, the Truth and Reconciliation Commission, and there you indicate that the findings and recommendations of the TRC straddle many departments of the state, different spheres of government. Some of the findings and recommendations fell within the mandates of the departments that make up the JCPS. Some of these related to the following: trying to determine the remains of people who disappeared, investigating and prosecuting people involved in abuses, pre-94 era, and then investigating networks and resources that remain unaccounted for. I want to focus on 8.2, investigating and prosecuting people involved in abuses during the apartheid era. Why would that be a particular interest for the presidency? Or put differently, why should it be part of the purview of the presidency?
In the first instance, commissioners, the president as the head of government head of the national executive, it is scarcely possible to imagine an area of government that would be of no interest to the president as the head of the national executive, particularly where the issues that fall within the mandate of any of the departments of the state would, for instance, have an item within what one referred to as the program of action of the government. In respect to the JCPS, as an example, the discharging of the responsibilities of the various departments in respect to the administration of justice, and that would refer to the capacity of the police to investigate proficiently, referring dockets for consideration on whether or not to prosecute by the prosecuting authority, that the judiciary is adequately resourced to adjudicate over those matters, including civil matters, and that where custodial penalties are handed down, correctional services is ready to discharge its responsibilities in respect to those who are sentenced to custodial penalties and all the other things that go with it. So that on its own is something that the president would be interested in. The cases arising from the TRC naturally straddle the normal functioning of the administration of justice, as I've just outlined, but they also particularly focus on those matters that were referred to government by the TRC for further processing. And in respect to matters outstanding arising, for instance, from people who had not appeared before the TRC, at least insofar as it had a process that dealt with applications for amnesty, or where there was somebody was denied amnesty and would have appeared before the TRC. Those are matters that would have been referred to government. And as head of government, the president and the office of the president would have an interest on those matters. I may add this, commissioners. This is not just unique to the JCPS. It would also attend those recommendations of the TRC or matters arising from the TRC that fell within the remit of other clusters, such as the social cluster, education, housing, healthcare, and that sort of a thing. So all of those matters would have received the same level of attention from the presidency. So there was nothing particularly unique in respect to the interest of the presidency on those matters that fell within the remit of the JCPS, as distinct from those matters that fell within the remit of other clusters.
One can certainly understand the interests of the presidency in pursuing these matters where perhaps there were challenges, shortcomings, and a need to mobilize resources. Although, would it extend necessarily, though, to a case-by-case oversight or monitoring in relation to the exercise of decisions in each TRC case?
No, it wouldn't. The presidency and the functionaries, for instance, within the policy unit, would not be involved operationally in any of the departments responsible for the administration of justice. But the presidency, represented by the policy unit, would be interested in ensuring and tracking any barriers to proper functioning of the government in pursuit of the objectives as outlined in a State of the Nation address or matters that the government has to attend to. So yes, the presidency would have had an interest in monitoring how matters arising from the TRC were proceeded with without it being operationally involved on a case-by-case basis.
If I can draw your attention to paragraph 11.1.5 of your statement, that's page 3. You make an interesting point there, that functionaries of the former regime continued to wield considerable influence by virtue of the resources that had been available to them. So you appear to be saying that even in the post-apartheid era, the functionaries of the former apartheid regime, and I assume you're referring more particularly to those in the erstwhile security sector of the apartheid state, that they could continue to wield considerable influence in the post-apartheid era. Would I be correct in saying that?
To a significant degree, you'd be correct. And what does one mean by that? It is pretty much established fact that the functionaries of the apartheid government were resourced by a government. They were not dependent for their responsibilities on raising funding from the donor community and that sort of a thing. Mobilize underground structures such as those who were in the liberation movement side of things. And they had enabling legislation, however one can characterize the laws that were applicable at the time. There were arms that were dispersed. There were cases there are particular operations that were carried out within the country and without the country. There were systems in place that, for instance, to this day, commissioners, the country doesn't have enough information on that. There are agents and sources of the former regime that remain unknown, or their status is not truly known, or the extent of what they were involved in is not known. And all of those and other factors I have not mentioned remain available for use on need by the functionaries of the former regime. I may add, for what it is worth, commissioners, that the government that obtained prior to 1994 had important and strategic alliances in the world. Many of the governments of the Western countries were really supportive of the government or the governments that obtained prior to 1994 and possibly even before 1948. And so that is a resource that somehow remains available to those people. I don't know if I mentioned this last time. It may have slipped my mind at the time if I didn't. Talk about the matter of someone like TRC September. It happens in Paris. She is the chief representative of the ANC, of the African National Congress. That already talks to the resources that were available to the government that obtained before 1994. And these are the resources that one is referring to without really exhausting the full list of the resources. But I hope I'm indicating exactly what is suggested by that line adequately for the purpose of the Commission.
Thank you, Mr. Jefter. And while we're on this topic, do you recall a secret project of the apartheid regime called Stratcom that was in the apartheid days attached to the State Security Council. Stratcom was short for Strategic Communications, and they carried out dirty tricks and specialized operations around deception.
Yes, and I'm aware of certain aspects of it. I wouldn't suggest that I know. I have wall-to-wall knowledge of what Stratcom entailed. And perhaps in that regard, I would have suggested last time I was here that language and its deployment was an important tool. And by way of making an example again, I tried to make a distinction between what was called force removals and what I consider to be possible to properly profile it as ethnic cleansing, where such obtained, as distinct from force removals, and that would be part of what Stratcom would have come up with, black on black violence. That would be another product of Stratcom.
So do you think it's possible that elements from the erstwhile apartheid regime could have employed Stratcom-type tactics and projects in the post-apartheid era to pursue their ends?
I have no factual evidence of it, but it wouldn't surprise me that purely what you can call lone wolf operations, somebody would have come from that background, would have pursued an operation that would be quite characteristic of a Stratcom type of an operation. But I wouldn't suggest that post-1994 that would have been carried out within government or in a discernible, organized fashion. Yes.
Yes. So we're also not suggesting that this was an official government operation post-1994. But in due course, we will be submitting to the Commission that the former elements from the erstwhile South African Police, South African Defence Force, State Security Council, that they did employ a Stratcom type of operation to manipulate the approach of government when it came to the TRC cases. And in essence, we will be submitting to the Commission that the deception that they employed was to suggest to senior people in government that the National Prosecuting Authority was on the verge of taking action against the ANC 37, including President Mbeki, and that the underlying rationale was to close down all prosecutions on the basis that if they proceeded against the former apartheid officials, they would then have to move against the ANC leadership. Do you have a comment?
I'm not sure, Commissioners, it is my space to comment on what submission is going to be made. It should be made on the basis of what is available to those who shall make such a submission. And maybe those who have to respond will respond at the time when such a submission is made. I may just suggest, for what it is worth, that powerful as Stratcom was, I'm not sure that it would have played a material role in influencing decisions about whether or not anybody was prosecuted. Further, and I tried to make this point last time, the step around deciding whether or not to prosecute has got to be preceded by and informed by the outcome of an investigation by the South African Police Services or any investigative authority of the state. And a decision to prosecute would be taken to a large degree on that basis, would be informed by a docket. Now, if the submission is going to be informed by the fact of the existence of dockets, and then notwithstanding the existence of dockets, then because of Stratcom, government was then persuaded to try and stop the prosecutions, that's another matter. But that would be my comment.
So just in relation to the notion that you put up about the existence of dockets, there were actually dockets in existence in relation to investigating alleged crimes committed by individuals within the ANC. For example, the landmine campaign. Those dockets existed, and the South African police were pursuing those cases. But by May of 2004, the NPA decided not to proceed with those cases, and they closed those matters. But notwithstanding that decision, certain police officers within the SAPS continued pressing for investigations to go further and for decisions to be retaken. Were you aware of that?
No, I'm not aware of that.
Yeah. You mention, I believe in your evidence in chief, that the approach around the TRC cases had its genesis in the speech made by President Mbeki in April of 2003. And as a result of that speech, government set up an amnesty task team. It was set up by the Directors General Forum, and that team then made recommendations to that forum. Those are set out under paragraph 6.5 of our application. So I just want to put the main recommendations to you for your response. The first main recommendation was to introduce new prosecution criteria in the NPA's prosecution policy to provide additional criteria not to prosecute TRC cases, and that ultimately did happen. Secondly, they proposed a departmental task team which included officials from the intelligence agencies, the presidency, and other executive departments. And then lastly, they recommended that this departmental task team, sometimes called the interdepartmental task team, play a role in advising the NDPP of the advisability of prosecutions in each TRC case before the institution of any criminal proceedings in those cases. What's your response to those recommendations?
Commissioners, perhaps I would need to be advised here. This doesn't come from me, that there was a decision to establish an amnesty task team. I think from what I read, that statement derives from someone else apart from me. And matters related to the amnesty task team would be best responded to by those who were in the constitutive meeting of this amnesty task team and the officials who represented whatever departments were in the amnesty task team. I I have my doubts. I would have to go back and look at some material, but I have my doubts about the suggestion that the presidency was represented in the amnesty task team. I seem to think that the presidency was not represented at the amnesty task team, and for that matter was not even represented once the interdepartmental task team was established. The presidency was not represented in that either. So I just thought I must state that at the outset. In respect to what is before me, the application, particularly 6.5.3, where it says, basically it says, if I can read it, it says, his, meaning my view, on the establishment of the task team and its recommendations to the Directors General Forum, including 653, its role on advising the National Director of Public Prosecutions of the advisability of prosecutions in the TRC cases before the institution of any criminal proceeding in each case. If that was provided for, and it is possible it was provided for, that wouldn't fit neatly with the legislation governing the activities and the mandate of the National Prosecuting Authority. I think that would be highly irregular to advise the NTPP on essentially whether or not to prosecute a case. What most definitely would have happened, and I'm saying this on the basis of my experience, having been in the presidency, would be for the departments to collaborate and share information, giving regard to the various differentiated mandates of the departments in the JCPS in pursuit of an integrated outcome, so to speak. I could be wrong here, but 6.5.1 must be talking to the prosecution policy that was established specifically to deal with these matters, that was ultimately set aside, I think, by the Constitutional Court. 6.52, the composition of the departments. I've stated that I have my doubts on whether or not the presidency was represented. As for the other departments, and giving regard to their legal mandates, I wouldn't have a problem with the participation of those departments if one has regard to their legal mandates.
Thank you. Just turning to 6.5.1, the insertion of the new prosecution criteria. Would you agree that this was also somewhat irregular, to put up specific criteria only in relation to a certain class of cases for a decision not to prosecute?
I must restate, commissioners, that this is something that I have no factual knowledge of, that I never participated in meetings of this amnesty task team. So I think that must be borne in mind. But if 651 is talking about the prosecution policy that was subsequently adjudged to have been unconstitutional, obviously then the view that this was irregular would sustain.
Yes, you make reference to the policy that was set aside by the Constitutional Court. It is in fact the High Court, Judge Lehodi, if I understood you.
Thank you for the correction, yes.
Thank you, Commissioner. And Mr. Jafta, just to be clear, we're not suggesting that any of this comes from you or that you were part of the Amnesty Task Team. We know that you were,
Yes.
you were not.
Yes.
Yeah.
Thank you. Thank you.
Although you, in relation to the departmental task team that was set up subsequently, some years later, you were listed as a principal member of that team, sometimes called the TRC committee, or the interdepartmental task team.
On the surface, it might appear that I was a principal member. In fact, I was not. I only attended the constitutive meeting of that. I suspect this fact can be, how would I say this? To establish this fact, one would have to look at the minutes of the meetings of the interdepartmental task team and look at the representation. I would imagine that the presidency does not feature in any of the subsequent meetings. The only meeting that I sat in was the constitutive meeting, which I think was chaired by Advocate Pikoli, who then handed over the day-to-day operations or functions or business of that ITT to Advocate Ramaide.
Since you raised the minutes, let's just quickly take a look. Do you have a copy of the cross-examination bundle? It might be that Lever Arch file. Commissioners, I'm referring, Mr. Jafta, to pages 183 and 184. So perhaps we can just start at 183. This is a list of the TRC committee members and then the principal members. It was attached to the statement of Assistant Commissioner Jacobs. So there you'll see the list. We're not going to go through them. And under principals, you're listed in the third row, representing the presidency. And then if we turn to page 184, this are the minutes of the TRC committee meeting, apparently the very first meeting. 12 October 2006, and you're listed as at number 4, representing the presidency. The minutes are there. I don't think we need to go through them. I think you're correct that it was initially chaired by Advocate Pikoli before he handed the chairpersonship to others. I think you are correct, though, that this is the only reflection of you attending a TRC committee meeting.
Correct.
Incidentally, we did pose a question to Dion Rudman, who was a senior official in the Department of Justice, and he was the chairperson of the Amnesty Task Team. And we asked him, why did they recommend that a member of the representative of the presidency be on the subsequent departmental task team, the TRC committee? And it was put to him that this was possibly because this exercise was a project of the presidency, and having a member of the presidency on the task team would help to keep the president informed of developments. And Mr. Rudman agreed with that proposition. Would you agree as well?
Yes and no. The task teams occur in government for a variety of reasons and in respect to multifaceted projects. Typically, reporting or accounting to government in respect to the business of task teams does not, in strict terms of governance, require a representative of the president to sit in each of the task teams. So to suggest unintendedly that that was intended to ensure that the presidency receives regular updates, I don't think that is correct. In terms of the constitutive meeting, the presidency would have had an interest in ensuring that the program of action is defined appropriately and the program of action is outlined appropriately. The operational issues that derive therefrom is not the business of the presidency, and accounting to the presidency would happen whether or not the presidency is represented in such a task team.
Thank you. Can we turn to a meeting that took place at the presidency in mid-2006? And information regarding this meeting comes from the affidavit of former NDPP Vusi Pikoli. And that affidavit is in the same bundle. I'm going to refer you to page 146 of that bundle. Paragraph 31. So I'll just read it into the record so we're all on the same page. So Pikoli writes, I then approached the presidency in order to secure the necessary collaboration of the parties to apply the prosecution policy guidelines. A meeting was arranged in mid-2006 by Reverend Frank Chikani, then Director General in the presidency. The meeting was attended by himself, the DGs of Justice and the NIA, Mr. Selebi, the Secretary of the Defense Secretariat, Mr. Jafta from the presidency, and I. Mr. Selebi again complained about Advocate Ackerman's involvement in the process. Do you have any recollection of that meeting?
In strict terms, no. Would such a meeting have taken place? I would imagine yes, it would have taken place, but recollection in precise terms of such a meeting, no. This is how commissioners, we would often do our work. If for whatever reason I picked up that there was a problem either with the policy or the coordination of a policy or a program, I would raise that with the then head of the policy unit and Reverend Chikane as the Director General in the presidency. And every now and again, when there was a need for that, then he would convene a meeting where the issues that couldn't be resolved would be Reverend Chigane would try to resolve the issues. And paragraph 31 suggests to me that this is one of those issues. That's why I'm saying I have no specific recollection, but what is outlined in paragraph 31 fits in with what would happen in the presidency at the time.
So according to Advocate Bakoli, in his oral evidence, he said that the meeting was called to attend to various problems and challenges, and these included securing investigators from SAPS, and then looking at the role of the other state departments on the task team, in particular SAPS and NEO, in relation to the role that they should be playing in the prosecution decision-making process. I assume, of course, this was a long time ago, so that you don't recall those kind of specifics.
Yes, I wouldn't remember the specifics. May I just establish some certainty? I suspect that my reading of paragraph 31 refers to the amnesty task team. That's how I'm reading it. So I just want to be clear that this is what, or is it is in respect to the departments that would collaborate in order to give effect to the provisions of the prosecution policy guidelines?
Yes, the latter, not the former.
Okay.
Because by then the amnesty task team had already concluded its work and closed down back in 2004. So this would have been the departments serving on the new departmental task team, or that so-called TRC committee. Let's then turn to paragraph 11 of your statement, where you make reference to a meeting that occurred later in 2006 at the home of Minister Zola Skweyiya, then Minister of Social Development, the late minister. And this meeting is also referred to in Advocate Bakoli's affidavit. That's at paragraph 32. And I want to read to you Advocate Bakoli's account of that meeting. At this meeting, it became clear that there was a fear that cases like the Chikani matter could open the door to prosecutions of ANC members. I quote hereunder from my affidavit filed before the Ginwala Commission as to what transpired at this meeting. The Minister of Safety and Security was concerned about the decision to proceed with the prosecution and with Advocate Ackerman's involvement in the process, and the issue of whether it was Ackerman or me who was behind the decision to prosecute. The Minister of Social Development was concerned about the impact of the decision to prosecute on the ranks of ANC cadres, who were worried that a decision to prosecute in the Chikani matter would then give rise to a call for prosecution of the ANC cadres themselves, arising out of their activities pre-1994. Let's pause there. Can I ask for your comment in particular on the concern raised by Minister Skweyiya that the impact of a decision to prosecute ANC cadres would give rise to a call for prosecution of ANC members themselves.
Commissioners, this is a statement by Advocate Pikoli based on his recollection. There are other people who are suggested to have been present at the meeting. It might be important to solicit their views about what transpired at the meeting. In other words, to test what Advocate Pikoli suggests happened at the meeting. Previously, when I appeared before the commission, I stated that until this morning, I really was unaware about the existence of dockets that would enable the NPA to decide to prosecute members of the African National Congress in the event the people who had attempted to murder Reverend Chikane were prosecuted. I really am unaware of the existence of those dockets. Now, it seems to me that it is being suggested that the fear was more abstract, if that's the word for it, than really informed by reality. And I find that construct somewhat to be inconsistent with the reality that I have lived. And for what it is worth, I'm going to put it like this. Being involved in the war for liberation against colonial rule and apartheid necessarily attracted adverse implications for those who elected to participate in that war. And such adverse consequences included precisely what was attempted on Reverend Frank Chikane. Now, if those who were involved in the war and the struggle for freedom could then later be characterized as being potentially paralyzed by an abstract fear of prosecutions, when many of them ended up in exile, incarcerated in Robben Island and such other places, I just find that construct to be inconsistent with lived reality. And that's why I suggested that if there were dockets, and I hear the point being made about the landmine campaign, if there was a factual basis that would trigger or cause anxiety and fear, I could engage with that, and I'm unaware of the existence of such. At the risk of repeating myself, I really cannot reconcile with a construct that suggests that fear on the basis of an abstract threat would be sufficient for government with a constitution to then wish not to prosecute those implicated in violations of human rights. I just find that construct difficult to reconcile with. And it would also not be consistent with the fact that the same government made sure, notwithstanding the limitations, or let me put it like this, there is no evidence, leave aside the part of the deal that talks to prosecutions, there is no evidence I'm aware of that anybody interfered with investigative work by the relevant authorities, notably in the South African police services. And if there was an anxiety about prosecutions, I would imagine if the suggestion is that because you have an anxiety about being prosecuted, and therefore you interfered with the prosecution, it stands to reason for me that you would have had the same anxiety if you get to know that there's an investigation and then you interfere with the investigation. But there is no evidence pointing to that I'm aware of.
So, Mr. Jafta, in short, to respond to Mr. Vani's question, are you aware of the concerns that were raised by the Minister of Social Development with regard to the impact of the decision to prosecute Reverend Chikane on the ANC cadres?
I am unaware of that, and that's why I was suggesting that, and I'm sure it's not for me to suggest to the Commission that this must be tested with the other people who are alleged to have been in the meeting.
Thank you, Chairperson. So, Mr. Jafta, I want to put it to you that this fear or concern was hardly abstract or out of the ordinary, because by this time there is evidence before the Commission that these generals from the apartheid era, through their attorney, a man by the name of Mr. Jan Wagenaar, they claim to have dossiers on the leadership. And the threat that was being made was that these would be released or made available to the prosecutors should their people be pursued. They even claimed that they were in possession of minutes of meetings that had taken place in Lusaka and the like. Furthermore, we're aware of other developments. Not long after the prosecution of the perpetrators behind the poisoning of Reverend Frank Chikane, not long after that of the plea and sentence agreement, a document comprising of a memo dealing with the landmine campaign was actually leaked to the press, to the Afrikaans press, which published it. The evidence of Advocate Ackerman is that that document was forged to give the impression that it was signed off in 2006, when in fact it dated way back into 2003. So given all these developments, I put it to you that this was not an abstract concern, it was a real concern, a real fear of government at that time.
Commissioners, I would really suggest that this be canvassed with those who are supposed to have had the anxiety. I have read what's in the bundle ascribed to Mr. Wagner, I've heard about people being in possession of minutes of one or the other meeting of some of the structures of the African National Congress in Lusaka. I'm aware that, at least if you're talking about the police, Eugene de Kock was arrested and prosecuted. I'm aware that the people who poisoned Reverend Frank Chikane were prosecuted, in fact, and other functionaries of the apartheid regime, few as they are, but still important. That did not trigger a chain of events that would justify the anxiety that is being talked about. So in other words, the generals, whatever they would have been threatening or suggesting that was going to be their response, I really have no evidence suggesting that whatever they threatened materialized after the prosecution of Eugene de Kock and other people, and including the people who poisoned Reverend Chikane. As a matter of fact, and maybe Reverend Chikane can best explain this, the meetings that he had with the relevant generals, at least in respect to the attempt on his life, I'm not aware that they ever suggested that there was this other option available to them if there was to be a prosecution of the people who had attempted to terminate his life.
Just as a matter of clarification, Mr. Jafta, Eugene de Kock was prosecuted some 10 years previously, in 1996, at a different time when these circumstances were not prevailing. The plea and sentence agreement in relation to Flocken van der Merwe and the others for the attempted murder of Frank Chikane, that took place in September of 2007. Are you aware that shortly after that plea and sentence agreement, Advocate Pakuli was suspended, and part of the complaints made against him was his handling of the Chikane matter? And Advocate Ackerman, who was the prosecutor in that matter, was relieved of his duties in relation to the TRC cases.
I'm aware of Advocate Pikoli being relieved of his responsibilities. I am unaware of the relationship between that decision and how the matter of the poisoning of Reverend Chikane was proceeded with. I'm unaware of that fact. And again, this would have to be canvassed by those who took the decision.
Just lastly, and to be clear, are you disputing Advocate Pakoli's recollection of what the Minister of Social Development said in that meeting?
I'm not disputing it. I have no recollection of him, of Dr. Square having said that, which is why I then prayed that this matter be canvassed with the other people who were in the meeting.
Yes, we will certainly do that when the opportunity arises. But just to make the point that Advocate Pakoli's affidavit before the Ginwala Commission, he prepared that not that long after these meetings. Let's turn to any recollection that you might have of any further meetings on the TRC cases in 2006 at the presidency. and these are also referred to in paragraphs 34 to 36 of Advocate Pacoli's affidavit. That's pages 148 to 149 of the bundle. So paragraph 34 on page 148, Advocate Pacoli refers to a further meeting that took place at the Office of the Presidency. That the task team would not make recommendations on a decision to prosecute or not, but it would receive all the necessary inputs and information from the various departments. Paragraph 36, there was a further meeting of ministers in the security cluster at the Office of the Minister of Safety and Security. This was attended by the Minister for Safety and Security, Minister of Social Development, Acting Minister Didiza. It's not clear to me whether that's the same meeting he's referring to, although this one was not at the home of Minister Squiggia, so I assume it's a different meeting. Do you have a recollection of these other meetings that took place in 2006?
Not in specific terms. Safe to say that my reading of paragraph 34 35 is what earlier we referred to as the minutes of that meeting of the interdepartmental task team. Not unless there is another meeting where Mr. Advocate Ramaite was assigned the responsibility to do this work operationally. So it seems to me that 34, 35, 36 refer to what was the constitutive meeting of the interdepartmental task team. I'm not sure if that meeting took place in the presidency. In other words, at the union buildings. I really cannot, I have no recollection in precise terms of where that meeting took place, but that's my reading of those paragraphs.
Yes, you're partially correct. They were referring to what this task team would do, although that task team had not met as yet.
Yes.
Do you recall in any of these meetings whether there was any opposition expressed to the role of Advocate Anton Ackerman in these cases?
In broad terms, there was I don't know if the word disquiet would explain, but there was a sentiment or some form of unease around the Advocate Ackerman and how he was running the business of government in respect to matters arising from the TRC. Yes, I remember that. But I have no specific detail in terms of what happened in what meeting.
Now, you've made reference to the role of the Justice, Crime Prevention and Security Cluster. And in the documentation, there's reference to a subcommittee of the structure known as the Cabinet Committee on Post-TRC Matters. Were you aware of this subcommittee? And if so, why was there a need for such a Cabinet Committee on Post-TRC Matters?
Commissioners, and I mean this with the greatest respect, I was not a member of cabinet, much less the head of the national executive. The decision to establish subcommittees of cabinet rests entirely with the head of the national executive, who was the president. And that was Mr. Thabo Mbeki at the time. I was not the spokesperson of cabinet at the time, and I think I cannot express an opinion on matters that fell completely out of my province, outside my province. This is a matter that is best left or canvassed with the head of the national executive and cabinet.
Let's turn to the TRC committee, or the interdepartmental task team that was set up as a result of the recommendation emerging from the earlier amnesty task team. And we know that it had its first meeting, I believe it was October of 2006. Can I ask how it was that you came to sit on that committee, or at least that first meeting? Who appointed you?
As part of my responsibilities in the policy unit, I sat in meetings of ministers, with DGs, or rather with ministers, or of ministers. I attended meetings of committees of the JCPS and subcommittees. All of that did not require a prior specific appointment to attend a specific meeting. And I would suggest that, in fact, I don't think there was a set of rules or protocols that governed which task team one would attend and what regulatory instruments one would satisfy before one attended. So I attended this specific meeting in the normal course of one discharging his responsibilities, as I had outlined right at the beginning about the mandate and the functions of the policy unit.
If I can draw your attention to your statement, 11.1.2, and actually we're going back to something that you say emerged from that meeting at the home of Dr. Skwiyiya. You mentioned that a proposal or idea in order to finalize cases arising from the TRC, two prominent individuals, one from the apartheid regime and the other from the ANC, could be identified for prosecution. In this way, I understood any party to the conflict over apartheid would not feel more prejudiced than the other side. This would have been raised as a point of principle, and no names of people were mentioned. Can I ask who raised that proposal or idea?
Commissioners, 11.1, maybe let me read it to the record. 11.1 reads, I attended several meetings that dealt with matters related to the work and report of the TRC. I also was in attendance when a meeting took place at the residence of the late Minister, Dr. Z. Skwiyiya. Although I have no specific recollection of the specific details of what transpired in the meetings referenced, I broadly recollect the following. 11.1.2. A proposal had emerged, a proposal or idea that in order to finalize cases arising from the TRC, two prominent individuals, one from the apartheid regime and one from the African National Congress, could be identified for prosecution. In this way, I understood any party to the conflict, that would be the former regime and the ANC, would not feel more prejudiced than the other. In other words, there would be parity on how the two parties to the conflict were dealt with. This would have been raised as a point of principle. In other words, a proposal or some idea, informal, and no names of people were mentioned. The last time I appeared before the commission, I indicated and I spoke to this point that at some point, there was a view that emerged that in order to bring matters arising from the TRC and its processes, it perhaps would be prudent to identify two prominent individuals from the apartheid regime and two prominent individuals from the ANC. I then explained that this was found to be seriously problematic for various reasons, one of which would be that an approach such as that, and I have no recollection of where this came from, but it certainly did receive attention. An approach like that would put on the same pedestal those who were fighting for apartheid and those who were fighting against apartheid. And this was found to be objectionable. And I did explain something that I referenced earlier, and maybe let me repeat that. I think it's 1973 when the United Nations pronounces apartheid as a crime against humanity, which it was. And that kind of an approach would fly in the face of that resolution by the United Nations. I did indicate earlier, like I did the last time I was here, that there were particular problems with the deployment of language, such as referring to ethnic cleansing, instances of ethnic cleansing, and then you refer to that as forced removals. So for those reasons, it would be really, it was argued, it would be very, very wrong to put on the same pedestal those who were fighting for apartheid and those who were fighting against apartheid. And I'm making the point at 11.1.2 that this had received attention. Whether or not it was specifically at the meeting at the house of Dr. Square or some other time, I do not know in specific terms, but this is something that did receive attention.
Thank you, Mr. Jefter. As a matter of interest, I would agree with you when you say that this tit-for-tat approach would have been a simplistic way of developing an approach to deal with apartheid-era cases. And coincidentally, around that time, I made a written proposal to the NPA advising against a tit-for-tat approach because it wouldn't take into account the context of apartheid and the fact that under apartheid, thousands of people had been prosecuted and persecuted for their political stands. So that context is important. On that score, we're on the same page. Before we close up, I just want to make sure that I think I've covered almost everything in your statement, but I'm now turning to my notes from your evidence in chief. And I just want to see, I think we've covered almost everything. In your evidence in chief, you mentioned that one of the reasons for the approach adopted by government was to help uncover the networks and find information about arms caches and the like. And for that reason, government came up with this new approach to TRC cases. My response to you for your comment is that government was always able to do that. It had the necessary tools, it had its intelligence services, and of course in the criminal procedure, it had section 204 where it could indicate, it could use state witnesses, and if they testified honestly, then they would be granted immunity. So I put it to you that the rationale that this approach had to be adopted for the TRC cases was something of a fig leaf. It was a justification put up in order to control the cases rather than to extract that kind of information.
The matters arising from the TRC are complex in the sense that at the one level, you would have to deal with the absolute operational functionaries. And these would be the people who would know where the body was buried, who pulled the trigger, who bent the body, how was it disposed of, where are the caches. At another level, you have to engage with those who formulated the policies, who gave the authorizations. So yes, these are matters that have received attention even prior to 1994. And dare I say, these are matters that should continue to receive attention. And it is almost like that universally in respect to transitions from totalitarian regimes to a democratic state. So yes, that was always the case. But in respect to these matters that arise from the TRC, they provide yet another opportunity for, if the departments work in a mature way, the police, the intelligence agencies, and such like, for them to exchange information, because in one case, make an example, in case X, you may find information that sheds light on something that is yet to be resolved on a completely different set of matters. And so there is never a time where you can, with a hard and fast rule, say, now there is no fit or relationship between what had happened before and what's happening in respect to the TRC cases and what happens subsequent thereto. This is an ongoing modus operandi, so to speak, because whether you're dealing with terrorist organizations, transnational criminal syndicates, you need this collaborative approach between the various entities that are responsible for the administration of justice and other responsibilities of the state.
Thank you. Also, in your oral evidence, you said that you were unaware of any attempt or effort to stop the law enforcement authorities from carrying out their legal mandate. Were you aware of the direction that then Minister of Justice, Bridget Mabandla, gave to the then acting NDPP, Silas Ramaita, in November of 2004, a direction that the TRC cases should not be pursued further until the development of guidelines to handle those cases?
I was unaware of that, Commissioners. And I remain unaware of it. Yeah.
Right. And were you aware of the struggles that the NPA had in securing investigators for these cases, a struggle that persisted from 2003 all the way to 2010, which effectively meant that apart from a few cases that had been previously investigated, and we're talking about a handful of cases in that regard, they were not able to pursue these cases because they were simply denied investigators until halfway through 2010.
I did state, commissioners, that there are other challenges that would have attended investigations in respect to the security apparatus of the government that obtained prior to 1994. And I did say that although there was great and mature collaboration between the various entities, the operations were still nevertheless very, very compartmentalized. In other words, they were underpinned by the doctrine of need to know. And for any investigation to succeed, you would need to secure collaboration with evidence from those who were within a particular unit that would have carried out an operation. This would not be an easy matter. I was aware that, and I'm even, having read this document, I'm more aware now that the police are supposed not to have availed the sufficient numbers of detectives, as an example, to do investigative work. But that's a matter that really ought to be canvassed with the police, having regard to a whole range of other factors or variables that obtained within the police, such as the number of detectives, the number of crime scene experts, capacity with the forensic science laboratories, etc., etc. So there's a whole number of other variables that would have to be looked into, and regard would have to be had to such other matters, such as the case cycle times. In other words, between when a case is registered with the police in a police station and when the case is ready for a decision on whether or not to prosecute, whether the variance between normal detective work was so different in respect to to detective work attending matters arising from the TRC. So that's what I suggested last time around, that it might very well be that if somebody looked into that, you might find that the cases arising from the TRC, which is bad, are typical of normal detective work, material outputs of detective work in the police. But I do not know for a fact if that is the case.
Chairperson, I see it's almost 1 p.m. And looking at my notes, I estimate that I will probably need another 15 to 20 minutes. So I just wanted to check with Chairperson whether you wish to proceed or adjourn for lunch.
Mr. Vani will continue until you complete your cross-examination.
As the Chairperson pleases. Mr. Jefta, also in your oral evidence, you mentioned that Frank Chakani had made various complaints about the role of the NPA. For example, that in a meeting that Advocate Ackerman had with him, Ackerman, to use your words, berated him, and he complained further that the NPA should have consulted with Reverend Chikani before the plea bargain with the perpetrators went ahead. So I just want to put it to you that under oath, both advocates, Anton Ackerman as well as Mtunzi Maga, who were present in that meeting, deny that version. And in relation to the consultations, advocates Bekoli and Ackerman assert that they consulted with Reverend Chikani on multiple occasions before the plea bargain. Do you have any comment on that?
Commissioners, I reported on a conversation that I had with Reverend Chikani. To be very precise, he could not have complained to me. He merely shared with me his experience of the meeting. If it is necessary, I will repeat that. As far as I can recollect, it is Advocate Pikoli who called seeking an appointment with Reverend Chikani, which request for an appointment was granted. And instead of Advocate Pikoli showing up for the meeting that he would have requested, it is Advocates Ackerman and Maga who showed up at the meeting with no suggestion from Advocate Pikoli that he was no longer coming to the meeting, but instead was sending the two officials from his office. I do have a recollection, not very vivid, that Reverend Chikani was quite distressed at what happened. It might be of benefit to the Commission to contrast what Advocates Maga and Ackerman say transpired at the meeting with what Reverend Chikani would say. And I do not know if he has canvassed this matter with the Commission. What I also stated was, in line with what Reverend Chikani said to me, shared with me, I would have expected that perhaps maybe the NPA could have explored exchanging notes with Reverend Chikani on what it is that he would have gleaned from his engagements with the people who tried to kill him and the supervisors of the people concerned. My recollection is that no such an engagement took place, but it was more like, what are you talking to these people about? Desist from further engagements, and if you continue, some penalties would attend such behavior. That's what I recollect, and it would be interesting to test the assertions by Advocates Maga and Ackerman against what Reverend Chikani would say about his own experiences.
Yes, just for the record, Advocate Pikoli testified that before that meeting took place, he had already met with Reverend Frank Chikani. But let's move on to what you testified in relation to a discussion you had with Advocate Menzi Simelane, who made some complaints around how the NPA at the time was dealing with plea bargains. And if my notes are correct, you indicated that Advocate Menzi Simelane was of the view that some of the perpetrators should have been given plea bargains in order to assist them to testify against other accused. Now, if that recollection is correct, then I must put it to you that that's not what plea bargains are designed to do. A plea and sentence agreement is in fact an agreement between the accused and the state as approved by the court. They're not then required to testify against other accused. There's a separate section dealing with that section 204, which does allow for state witnesses to give testimony in exchange for immunity if they testify honestly. Do you accept that?
I accept that, and I must repeat what I said, that I wish that I shouldn't be requested to elaborate on what it is that we're talking about. It was by way of making an example, and I can assure the Commission that the matter we're talking about had absolutely nothing to do with the Truth and Reconciliation Commission. Absolutely nothing.
And later in your oral evidence, you mentioned that prosecutions against senior figures in government, which might require them to step down from office, could paralyze government. And when you were asked, I believe, by Commissioner Gabriel whether that was an academic notion or a real threat, you said it was in fact an actual threat. So what I wish to put to you is, given that it was an actual threat, surely that then adds to the assertion that the families make, and that this threat did feed into the concerns held by government and help to shape their approach to these cases.
Commissioners, the matter arose somewhat differently. Whether or not prosecuting, and as an example, the 37 members of the ANC would constitute a threat to national security. And the point I made was that theoretically, if you were to prosecute, as an example, if you make an allegation against a sitting president with a view to prosecute, it would stand to reason that that president would have to step down and leave the office of president for very, very obvious reasons. Now, why was this? This was not canvassed by me to suggest that this was an anxiety that would have caused government to interfere with prosecutions. I restate that I'm unaware of an instance where government interfered. The point made earlier about Minister Mabandla corresponding with Advocate Ramaite was unknown to me. The point about it is, theoretically, you can have a scenario where, suppose, theoretically, you mount a prosecution against a president and several ministers on account of them, in this particular example, having been members of the National Executive Committee of the ANC, you can paralyze government. Particularly where you can so mount such a prosecution with a reasonable, within reasonable bounds that in fact there might be no successful prosecution. And that is very, very possible. So in that case, yes, that would undermine, that would cause a precedent. But it has no bearing. I restate the points I made earlier, that I'm unaware of investigations, I'm unaware of dockets that were referred to the NPA for prosecutions, and I remain convinced that no such an anxiety existed based on any facts.
Right. Well, on that score, I'm sure you're aware that we will be submitting to the Commission that there was this anxiety. But may I refer you to what you said in relation to your role on the interdepartmental task team? You had an exchange with Advocate Seme, that you attended the constitutive meeting, and you said the following. It wasn't clear to me whether it was about the ITT or other meetings. You stated, "Now, I have just said I attended many meetings. Does that mean I was operational? No. But I was close enough to know what works and what does not work." Can you explain what you meant by saying I was close enough to know what works and what does not work?
Commissioners, this arose when I was making an example about a visit I was a part of to the borderline between South Africa and Mozambique, where on a particular day of the week, and I don't know which week it is, the same communities separated by a fence now are Mozambicans on the other side and South Africans this side. And there's a market day, and they trade on all manner of goods, tobacco, alcohol, small animals, goats, etc., with the borderline at the time being patrolled jointly by members of the South African Police Services and the South African National Defence Force. And adjacent to that specific area, there were reports that syndicates or members of criminal syndicates from Mozambique would steal sports utility vehicles from the South African side and simply speed into the fence and drive into Mozambique with such. And the legal system on the other side of the fence made it almost impossible for such vehicles to be repatriated back to South Africa. So considering all the facts around managing security along the borderline, I would know what works and what doesn't work. That arose in that context. Now, you can extrapolate and say what I was suggesting, which is true, is that in respect to quite a wide range of other issues within the purview of the JCPS, I would know what works and what doesn't work. Simply because and this is not just true of Loyiso Jafta, it is true of the other colleagues in the policy unit who were responsible for the other clusters, because you needed to keep your finger on the pulse of what it is that works and what it is that doesn't work. And that arises from the monitoring and evaluation function of the policy unit.
So yes, I recall that exchange. It was actually in a response. It was a question that Advocate Seme put to you after you had said that you were involved in lots of task teams, not just this one. And she said yes, but you did not get involved in every instance of crime. And then you gave the example of the issues that arose on the Mozambican border. So yes, one, you know, and that's obviously a very legitimate exercise to try and work out what will address those issues, what will work, what will not. But I want to put it to you that you know, that kind of work is very different to a task team that involves itself on a case-by-case basis as the interdepartmental task team did. And in fact, there was a point where the representatives from SAPS and NEA insisted that before the NDPP could act in any case, he would need to wait for a recommendation from the task team and indeed the DG's forum. Would you agree that there's a big distinction between that example and the task teams that deal with issues that arise, for example, on the Mozambican border?
Absolutely. But commissioners, I would also want to, and I'm not nitpicking here, please don't misunderstand me. The reference to NEA and the police asserting that they would have to advise the NDPP. Actually, in the minute that was referred to earlier, that in the minute that ascribes that matter to have been raised by a member of the Directorate of Special Operations, DSO, and not NEA or SAPS. But the commission can go back to the minute. But my recollection is that that matter, in principle, I agree, it is wrong. But factually, at least as far as the minute is concerned, that matter was raised by a member of the DSO and not a member of either the police or the... It's just that I don't want to distract the commission, but that matter was raised by a member of the DSO.
Yes, Mr. Jafta, can I suggest we don't go into it, because we're not relying on that minute to make that assertion. There's other documentation, and indeed there is a letter to that effect addressed from the then Commissioner of Police, Salebi, to the NDPP,
Okay.
setting that out, which then caused a crisis, because that was a bridge too far for then NDP Pikoli. It then caused him to write a memorandum to the Minister of Justice, setting out his concerns that his office, the independence of his office, was being undermined. If you like, I can find those documents to put to you, but do you accept my word that that is in fact what happened?
Commissioners, I've just stated that in principle that would be wrong, whether it is by the late Commissioner Sileve or by the member of the TSO. In principle, that would be wrong in law.
I'm just skipping over questions that I believe we have canvassed already. Yes, perhaps one last question from the oral evidence. Commissioner Gabriel put a question to you as to why nation building was at odds with the TRC process, and in particular in relation to the prosecution of the cases emerging from the TRC. And in relation to the pursuing of cases where amnesty had been denied. And your response was, these were very complex matters, and you gave various examples of what had emerged from the TRC that needed to be addressed. But in relation to the prosecutions, you said this was not a problem if done in the spirit and letter of the law. Or put differently, if it was not done in the spirit and letter of the law, it would be a problem. What did you mean by that?
Let me go back to my conversation with Reverend Chikane. I genuinely believe that he felt aggrieved by how he was engaged by the team from the National Prosecuting Authority. And I'm not suggesting for a minute that you can then use that and generically say that is how the NPA would deal with all other matters. But the point that I was making there is that you have to implement, and that goes for almost any other business of government and not just TRC cases, implement it in accordance with the spirit and the letter of the law. And I did say prosecutions of themselves have absolutely no bearing on national security. I did state that.
And then finally, there is evidence before this commission that post the winding up of the TRC, although there were initial efforts to follow up the TRC cases, the ones that had not been amnestied, as we stand here today, more than 20 years later, very few cases have gone ahead, which is really the reason why this commission is now sitting and investigating. Do you have any comment on the fact that so few cases have proceeded since they were handed over to the NPA some 20 odd years ago?
Commissioners, I wouldn't want to come across as being insensitive to matters arising from the TRC. Far be it that would be the impression. The matters arising from the TRC are multifaceted, and I know that this commission is dealing principally with the investigations and the prosecution of those matters. I could be wrong, but I suspect that, yes, for a start, I wouldn't be satisfied that so few cases have been concluded through a prosecution. But I suspect that in respect to other matters arising from the TRC falling within the remit of other structures of government, you are likely to find the same kind of unacceptable pace. Restitutions and a whole range of other issues, looking for and extracting, exhuming the remains of people who remain unaccounted for. There is real pain. I should, in all honesty, apologize for this. I did talk about my personal circumstances, and I should not have, because I don't want to raise the personal circumstances of my parents as though that was the most important thing, or I'm abusing sitting here to elevate that matter.
Yes, but you don't have to apologize for that.
Yes. Thank you, Commissioner. But But the truth is, the point one is trying to make is that it is very, very possible that what you find as an outcome and possibly the impact of government interventions on matters arising from the TRC, you may find the same kind of outcome or outputs in respect to a wide range of other issues. Maybe perhaps with the exception of the change of place names, Port Elizabeth to Gqeberha and that sort of a thing, you may find that there's an appreciable spike on that level. But otherwise, I have my doubts about what government has done. I have to raise this as well, commissioners, that truly, if you were to ask for my opinion, there is no greater restitution for matters arising from the TRC than the attainment of freedom itself and the constitution that we have that should ensure that such abuses never recur in this country. The greatest thing that has happened to the people of this country, outlined in the constitution, is the greatest thing that South Africans have achieved to put an end to colonial rule and apartheid. That's what I would want to end on.
Thank you, Mr. Jafta. I think we can certainly agree with you on your last point. But in relation to your assertion that the failure to proceed with the TRC cases over all this time is similar to the failure to deliver in a range of other matters, I think there we would have to disagree with you. So, for example, the work of the Missing Persons Task Team, they've done amazing work, actually. They've recovered a large number of bodies. They have returned remains of missing people to their families, and they've assisted them to restore dignity in all those cases. So that's an example where there has been significant delivery. And I'd like to put it to you that they were able to deliver because no obstacles were placed in their way, but obstacles were placed in the way of the attempts to achieve justice in the TRC cases.
I honestly have I wouldn't want to comment on that. Yeah.
Chairperson, my 20 minutes is up. No further questions.
Thank you.
Mr. Jafta, one aspect, if you can go to paragraph 8 of your statement, reading more or less from the last sentence, some of the findings and recommendations fell within the mandate of the departments that make up the JCPS, which is the Justice Crime Prevention Cluster. And then 8.1 says that, some of this related to the following. 8.1, trying to determine the remains of people who remain unaccounted for, which is incidentally an aspect that you have touched on. On the 9th of June 2020, there was an interview by a journalist, Hofstadter, with Mr. Wagner, who represented generally the security forces, for some of them. And Mr. Wagner suggested there was this impediment, and if you could go to page 49, red number. 31 of the interview. If
Page 41.
Page 49, 49, red number. And it's 31 of the, or maybe page 10 of the interview, or
Yes.
black number 31. There are 3 numbers.
Yes.
Each one could take you there. Have you found it?
Yes, yes, Commissioner.
Yes. Now, I just want to read this to you, what Mr. Wagner says about the impediment, particularly of the recovery of some of the bodies of the missing people. He says, if one reads from more or less line 6, he says there, and then I said to her, in other words, to Dr. Jobson, because my memory serves me right, I said to her, but let's suppose those missing people were murdered by the security forces. I think it was at that discussion, I'm not sure. I think then I said to her, Dr. Jobson, that suppose that was the case, you can't expect those people to come forward and say, we killed someone and we buried him there and there and there. If you merely want the remains because there is no legal privilege attached, I think that that is what I said to her that day. You need a process where there is legal privilege. And that directive, that prosecution directive, created a situation of legal privilege. And down there, he carries on. Yeah, I said to her, but you people, you were the people who took that thing to court to have it declared unconstitutional. And I think that that was an opportunity missed. Now, if you take what you have said at 8.1 there and what Mr. Wagner says here, let me ask first, did we at any stage have maybe met Mr. Wagner and if you at any point discussed something along these lines with him?
Commissioner, I never met with him, and therefore I never had a discussion with him on these matters.
And now he says, if I understand him correctly, the reason why some of the missing people that were murdered by security forces, their remains have not been recovered, is because of what, let's just say, basically the Galata group or whoever, or maybe the Ms. Similani who took this matter to court. In other words, if they did not do so, the remains of these people may have been recovered. What do you say about this attitude? I don't think he's speaking his mind. I think he speaks on behalf of his clients.
Commissioner, thank you. It speaks in part to a point I had made earlier. The there are people who were captured by the security apparatus of the former regime, tortured, and their remains disposed of. There are cases that are known, and there are cases that may not be known, because there are people who would have been intercepted, tortured, and killed because of mistaken identity. So it's not always the case that people refer to here will all of them, in all circumstances, be activists. Now, the operatives who would apprehend a person, torture him, and get him killed and dispose of the body would not be a very large number. In order for you to get to the nitty-gritty of the detail, one of them has to come forward, one way or the other. The circumstances will vary from one case to another. There are examples one can make mention of. There are people who were apprehended. We know that to be fact. And they are not accounted for. But you know the police station where they were last in some form of detention or custody of the state. Typically, when somebody went into the custody of the state, say in Lady Brand or a place such like place, almost always bordering one of the neighboring countries, you can make an entry into the investigation through there. You would know who was the officer commanding on duty on the day. But then the obstacle would be to get to the actual functionaries who can take you there. That's one level. But you need the enablers of this kind of an operation. And that's where you have to go to the policymakers and those who approve the operations. My experience is the operatives, and particularly their supervisors at a policy level and other levels, say at the level of an accounting officer, I don't think they were ever keen, and this would vary from one department to the other. I don't think they were ever keen on the very project of transitioning from apartheid to democracy. And because of that, you are going to find varying degrees of a willingness to assist the country to resolve, in the case of what we're talking about, this specific matter of people who are missing. You will make a bit of success with a Eugene de Kock because of his specific circumstances, and it can help you. But anywhere else in the security apparatus, civilian or military, where you don't have a Eugene de Kock in that environment, you are not likely to make a lot of progress. Were they not cooperating as a collective? To be sure, they were cooperating. But there were such strict rules that governed who knew about which operation. And this attitude that is displayed here, you will find it almost across the spectrum. You'll find it across the spectrum. It is remarkable that the identities, the names and the faces could be matched to the people who poisoned Reverend Chikane. It is not always the case that you can do that, where you can match a face and a name to a particular incident. It is exceedingly difficult. There was an incident, commissioners, where I chanced upon a fella who didn't look well, somewhat inebriated, heavily, in fact, not somewhat, who with absolute glee talked about how someone I knew personally had been shot dead. It's an extrajudicial killing. And I went back, you listen, and you listen, and you listen, and then you go back and you talk to the people charged with this responsibility and say, but there's a chap who was inebriated, boastfully talking about how somebody was killed. So we went back. I don't think we offered him more brandy than he already was in his system. But he was quite incoherent. But I have no doubt in my mind that if we spent a little bit more time with him, he would have taken us to the detail of what happened. I'm extremely hesitant to say what I'm tempted to say now. Because it might come across as being opportunistic or insensitive. You can think about Mtlenge and how he was killed. A lot happened. I think some of you know Justice Shabalala and his wife. I could be wrong. I don't think that matter has been resolved. Yet it's not a crime that happened in a remote place at 2 a.m. in the morning. I think his wife was killed very, very brutally in such a manner that that matter could have been resolved in the same way. So there are many of these kinds of cases. I may as well abuse my being here. I think President Mbeki himself lost a child and maybe another sibling to the same kind of. And these are mere examples. There are numerous other families spanning generations who have got this wound that will never heal.
Yes. Let me ask you perhaps an unfair question. It may be said, qua vadis, where to from here, particularly for people who have lost loved ones, to try and find more of these missing people killed by the forces and so on. Where to from here? That's unfair as a question.
Yes. Commissioners, this is not a theoretical conversation. It helps to highlight the importance of this work, just this one, as an important pillar for the transition into a young democracy that is maturing. I am aware of some efforts that are being made, and maybe it should be that such efforts must be given more resources, broadly defined, to put a bit more effort into this work. The typical answer, which is implied here on page 49, is that those who were involved have got this anxiety that if they so disclose, such a disclosure is going to attract a legal process with adverse consequences for themselves. But there must definitely be more effort and resources invested on this work, because many of these people who did these things are still alive. Many of them are still alive. But the number is decreasing, and the memory as well, and the markings on the graves move as well. And some of them were not really. I'm thinking about a particular case now where the person was a gardener, really. The person was a gardener, working in the garden, attending to the gardens, but was just beloved by this official. And the person would talk about how they would smash the skull of a person in custody and dispose of the remains. Such people you can have conversations with such people, but the difficulty is, how do you give an assurance that once such a disclosure is made, then you shall not be prosecuted?
Yes. Are you through? Thank you, Mr. Jafta. Thank you, Chair.
Thank you.
Ms. Seme?
Thank you, Commissioners. I just have one issue that I want to converse with you. It's on the ITT. You are aware that there were further meetings of the interdepartmental task team, apart from the constitutive meeting.
Yes.
And you did not attend those meetings?
No, I did not.
Commissioners, it's not part of the bundle that Mr. Bunny provided, but in Mr. Jacobs' affidavit, I'm trying to check on my notes, and I did make the note, and I want to place it on record. That a meeting took place on the 25th of October 2006. It's PCJ4 of Dr. Jacobs' bundle at page 1721. There are minutes of that meeting. You will note that Mr. Jafta is not present in that meeting. Again, on the meeting of the 6th of November 2006, PCJ6, page 1735 of Mr. Jacobs' bundle, a meeting of the ITT takes place. Mr. Jafta is not present. The further meeting of the 16th of November 2006 at page 1750, ITT meets, Mr. Jafta is not present. The last one again on the 4th of December 2006, PCJ 10, page 1752, Mr. Jafta is not present. I haven't noted the one that took place in January 2007. Again, in that meeting, Mr. Jafta is not present. And can you comment on why you were not present in all those meetings?
Thank you. Commissioners, I would not have attended because those would be what I consider operational meetings. It's actually the task team doing the work, and I would not attend that meeting for that reason.
Thank you, Commissioners. That is all I wanted to place on.
Thank you. Mr. Jafta, we wish to express our gratitude for your attendance at this commission to give evidence before it. You are now excused as a witness.
Thank you.
For attending. These proceedings are adjourned until tomorrow at 10 o'clock.